I think we're very fortunate in that, at least at the state level, I think the federal criminal justice system is in question now in terms of what its direction will be. But at the state level, we're at an historical point where on both sides of the aisle there's quite a bit of agreement that the prison systems have grown too large, in some instances that we have too many people on supervision. There's certainly more awareness of issues like collateral consequences and economic sanctions, simply the monetary burdens that we place people under who are struggling to get back on their feet in the first place. The sensitivity to that range of issues is much greater now than at almost any earlier stage of my career, or maybe going back to the 1960s. Part of that is that for the last 25 years, crime has largely been dropping, so there's more room, there's more psychological room to think about change.
Collateral consequences in recent years have proliferated. And by collateral consequences in this context, what we mean are long-lasting extra criminal case sanctions that can affect individuals who are convicted of crimes. Many of those consequences, which are codified in civil law, aren't known to individuals at the time they enter a guilty plea or are convicted. And some of them matter in significant ways. A lot of the more serious collateral consequences, like deportation or sex offender registration, are better known, but there are thousands of smaller consequences, often unknown to individuals at the time of sentencing. What the new code does is require that courts, with guidance from the Sentencing Commission, notify people of the main restrictions to which they are going to be subject when they're convicted, and also let them know that we can't tell them all of the consequences that might attach to conviction, because one of the unique aspects of collateral consequences is that they can be retroactively applied, so new ones may come into force many years after a plea is entered.
When I look at the code as a whole and the role that it could play in the next 20 years, my optimistic self tells me that there is sentiment to change what the country's been doing in criminal justice and in criminal punishment and sentencing in particular. But sentiment doesn't get you very far unless you have solid suggestions for how to get the tire to meet the road, how to change things, how to implement an idea so that it actually has a chance of occurring instead of just being vaporous and never taking any kind of a solid form. And I think what's so valuable about the code is that it would give jurisdictions a lot of tools that have, for the most part, been tested and proven, at least in several states, for doing the kinds of things that many people are talking about. So I'm hoping, again, my optimistic self is hoping that the sense of the moment that the pendulum may be swinging is an important national fact. But to capitalize on that and to make real change, the ideas have to be there at the level of government and courts and administrative law and individual cases. And I think the code will supply that.
So one of the things we try to do in the revision is make sure that we were capturing in either legislation or principles for legislation practices that we see on the ground, but that often aren't reduced to statutory guidance. That includes things like deferred prosecution, for example, deferred adjudication, and victim offender conferencing. And in crafting statutes or principles for legislatures to consider when drafting statutes, our hope was to take the best of the practices that exist on the ground and codify them or reduce them to writing, and then also to give guidance about some of the main areas of concern where these practices have either been abused or have led to criticism by those writing in the academic community or by practitioners themselves.
One of the things I'm proud of in the current draft that's coming before the membership this year in 2017 is that the code takes a general philosophical position on how to think about the victim's role in the sentencing process. And many practitioners would tell you in criminal litigation that one of the things that has changed the most in the last 30 or 40 years is the involvement of victims, the awareness of victims' rights and victims' procedural rights and sensitivity to victims' interests. And in the discussion of how this should evolve, it's still a fairly new, 30 or 40 years to me, is a fairly new component of our criminal justice system. If the question is asked, where could you go and look for one source that would consolidate what the most informed advocates for change are saying today, where would you look and how would you go about doing that? The model penal code is going to be a very good place to start. It's going to be a foundational document for jurisdictions that find that they have that sense of political will. And that was something we didn't know when we started the project. We didn't know the political winds would change. But it would concern me greatly that the contemporary sense that America just needs to go in a different direction when it comes to criminal justice, if that were just to have evaporated because no one knew how to do it in implementation terms. And I think that's where the ALI comes in. I think that's where the model code comes in.